A timeless tune, a blockbuster film, and a courtroom in the middle. Yes, I am here to talk about a case at the intersection of Indian classical music and contemporary creativity, and a first of its kind judicial conversation involving Indian classical music. Ustad Faiyaz Wasifuddin Dagar sued Mr. Rahman, Tips Music, the singers, and the producers of the Tamil film Ponniyin Selvan-II over this song. Why? Because of this song. Stating that Mr. Rahman and the others used the original Shiv-Stuti composition composed by the junior Dagar brothers during the 70s without any form of consent, authorization, license, or without giving proper credits, and that it is an infringement of Mr. Dagar's copyright. So now let's see how did the court decide on this matter and what's currently happening and what did both the parties argue. So now the first issue that the court took up in deciding this was whether Shiv-Stuti could be considered original under the Copyright Act provisions to enjoy copyright, and whether the junior Dagar brothers were the owners of this copyright. In arguing this, Ustad Dagar stated that this was a joint work of authorship of the junior Dagar brothers and this composition was written by the junior Dagar brothers in the 70s. He also placed various documents including published treaties and a family settlement that stated that he was the legal heir of the Shiv-Stuti composition. On the other hand, Mr. Rahman and the others, in arguing this matter, stated that the Shiv-Stuti composition belongs to the Dagarwani style under the Drupad tradition, and therefore it falls under public domain, whereby it's not original and not copyrightable. However, the court in deciding an issue stated that the Shiv-Stuti composition belongs to Rag Adana. Now, Rag Adana may fall under public domain, but the specific arrangement of the Shiv-Stuti within the framework of a rag, the notations, the repetitions of the swar, the alaps, everything is unique and therefore original and copyrightable. So now that the originality and the ownership of the Shiv-Stuti is established, the court moved on to the second issue, which was whether Veer Raja Veer actually infringed upon the copyright of Shiv-Stuti. Alright, so now first thing, let's break down the composition. Shiv-Stuti was based on Rag Adana, was set in Sultal, which is a 10-beat tal cycle, and was completely based on Indian notes. In response to this composition breakdown, Mr. Rahman argued that his composition was purely based on Western fundamentals and Western music notes, and that it had 227 other layers which were not originally present in the Shiv-Stuti composition, and therefore it was merely inspired from the Dagarwani tradition and not a copy. He also said that his composition was not specifically and entirely set to Rag Adana, and that it had elements present from Rag Bihag, Rag Darbari Kannada, Rag Jaunpuri due to a mid-song pitch change. He also said that his composition was based and set to Ardha Japtal, which is a 5-beat tal cycle. So in deciding on infringement, कोर्ट दो चीज़ें देखती है. एक हो गया एक्सेस, मतलब क्या डिफेंडेंट्स के पास शिव-स्तुति का एक्सेस था to even have copied it? The answer to which was yes, because the composition was very easily available on public platforms, and also that the singers of Veer Raja Veer song were students of Ustad Wasifuddin Dagar. Second thing is whether both the songs were substantially similar to be called copies of each other. The answer to which was also yes. The court said that Veer Raja Veer was not merely an inspired composition from the Dagarwani tradition. The underlying work was completely same. So even though there were other layers added and the 227 other elements added, it may have made the composition modern, but the basic work is still the same. And the soul of the composition was copied, was what the court said, based upon the precedents and previous cases, and also that अगर कोई आम आदमी इन दोनों गानों को सुने, जिसने गाना ना भी सीखा हो, अगर वो भी इन गानों को सुनता है, क्या उनको ये सब्सटेंशियली सिमिलर लगेगा? इसका जवाब भी हाँ था. So eventually the second issue was also decided as there was infringement. अच्छा, तो अब इस केस के साथ हो क्या रहा है या क्या हो चुका है? So the interim order on this case was given in April 2025, and the order said that we are not restraining the use of this song in the film because the film is already out in public since a long time. But the court said that credits must be given to the junior Dagar brothers and acknowledge them as authors. Secondly, the court also asked the defendants to deposit rupees 2 crores as security while the case is still ongoing. And here's the twist. The Delhi High Court on 6th May 2025 stayed this order which was given against Mr. Rahman, and they have challenged this order. So let's see what happens now. We'll keep you updated. But artists and legal professionals, let's start a discussion about where is the fine line between inspiration and infringement. Thank you.